Good afternoon. Welcome to another episode of The Law and You. Today we'll be looking at a very interesting topic. That is the appointment of judges in Guyana. After interacting with some persons, I've realized that a large section of Guyana's population do not understand how judges in Guyana are appointed. This topic also ties into our discussion on the Constitution. Before I begin on speaking about the appointment of judges, let me tell you how judges are not appointed. Some persons believe that you study for a number of years in a specific area of law and you can become a judge automatically. That is not so. There is no course you can study to become a judge in Guyana. Likewise, you cannot be a lawyer for a number of years and then automatically become a judge. It is not so. Additionally, a person cannot be a magistrate for a certain number of years and then automatically become a judge. There are laws in Guyana which provides for the appointment of judges and other judicial officers. The most important of those is the Constitution, which sets out how judges are appointed, the Chancellor and the Chief Justice, as well as what the qualifications of judges should be. By virtue of Article 122A of the Constitution, the judiciary and all personnel under are independent, meaning that the court, the judges, the Chancellor and Chief Justice, even the registrars of the court, cannot be given orders by either Parliament or the executive government. Before I speak on how judges are appointed in Guyana, I must first mention a very important body. That body is the Judicial Service Commission, or JSC for short. The JSC serves a very important role in our judiciary. The JSC makes recommendations of who are to be appointed as judges and also for the removal of judges. It comprises of, first, the Chancellor of Guyana, who serves as the chairwoman of the commission. Likewise, the Chief Justice sits on the JSC and the chairman of the Public Service Commission. There's also a current or former judge from Guyana or the Commonwealth, as well as either one or two non-lawyer members. Those members cannot be public officials, have no political affiliation, and they cannot be members of Parliament. Together, that commission, the JSC, makes recommendations to the President on the appointment of judges. A judge, that is, a judge of the High Court or the Court of Appeal, can only be appointed by the President with the recommendation of the JSC, meaning that the President is the one who makes the appointment of these judges, but he can only act in accordance with the recommendation given by the JSC and no other way. For a person to become a judge, they must apply to the JSC. The JSC then assesses that person's application and makes certain recommendations to the President, who must act on such recommendations. To qualify to be a judge in Guyana, a person must, one, either be a judge in a Commonwealth country or be admitted to practice as a lawyer in Guyana for over 10 years. There's also provisions for part-time judges. Part-time judges go through the same recommendation from the JSC. They must apply, the JSC must recommend their appointment to the President, and then the President makes such appointment. Otherwise, they cannot be appointed as part-time judges in Guyana. To be appointed as Chancellor or Chief Justice, there's a different hurdle to be crossed. Unlike a normal judge that just needs a recommendation of the JSC, Chancellor and Chief Justice needs the agreement of the Leader of the Opposition. Therefore, the President and the Leader of the Opposition must meet and discuss this appointment before a Chancellor and Chief Justice can be appointed to a substantive office. In Guyana, the High Court and the Court of Appeal together form the Supreme Court of Judicature. The Chief Justice is the head of the High Court, while the Chancellor is the President of the Court of Appeal and head of the entire Supreme Court of Judicature. As you know, in Guyana, we've had many acting chancellors and many acting chief justices. The appointment to those offices of acting chancellor and acting chief justice does not require the approval or the agreement of the Leader of the Opposition. What is needed is for the president and the leader of the opposition to have meaningful consultation, but not necessarily agreement. The meaning or the definition of meaningful consultation is one that is up for debate, and we will not get into that today. The term of office for any judge ranges from 62 years for a normal judge to 65 years, or 68 years for the chancellor. The Caribbean Court of Justice, which is our apex court, meaning our last court of appeal, has a different process. This court was created by CARICOM, the revised Treaty of Chaguaramas, and the agreement establishing the Caribbean Court of Justice. The president of the court, which sits at the head of the court, is a judge from the CCJ, but is only appointed with 3/4 majority vote by member states based on the recommendation of the Regional Judicial and Legal Services Commission. However, for the other judges, they must simply be majority vote by the members of the Regional Judicial and Legal Services Commission. Judges of the CCJ have a tenure of 72 years, but can be further extended to 75 years as a sitting judge at the CCJ. On our next episode of The Law and You, we will discuss how judges are removed from office. However, let's recap today's session. 1. You cannot specifically study a particular course and become a judge. 2. After being a magistrate for a number of years, you don't automatically become a judge. Likewise, after being a lawyer for a number of years, you don't automatically become a judge. To be a judge in Guyana, you need to have been a judge in a Commonwealth country or a lawyer in Guyana for over 10 years. You need to be recommended by the Judicial Service Commission, and only then can the president appoint you as a judge. To be chancellor or chief justice, however, there must be agreement between the president and the leader of the opposition on who those persons should be. To be acting chancellor or acting chief justice, there must only be meaningful discussion or consultation between the president and the leader of the opposition. Thank you.